Welcome to our video guide on switching from a K-1 Fiancé visa to an I-130 Immigrant Petition for alien relative. In this video, we'll walk you through the important steps and considerations for making this change. We'll also highlight the key differences between these two types of applications and provide valuable insights into why you might want to switch. Remember, this is general information, so always seek professional guidance for your specific circumstances. Here's what we'll be covering in today's video. We'll start by understanding the differences between a K-1 Fiancé visa and the I-130 Immigrant Petition. Next, we'll discuss the reasons you might want to make this switch. Then, we'll go over the process of switching from K-1 to I-130. After that, we'll talk about some important considerations you should keep in mind. Finally, we'll cover a disclaimer about the information in this video. Let's dive into understanding the differences between the K-1 Fiancé visa and the I-130 Immigrant Petition for alien relative. The K-1 visa allows a foreign fiancé to enter the United States with the expectation of marrying a U.S. citizen within 90 days. If this doesn't happen, the visa becomes void. On the other hand, the I-130 petition is filed by a U.S. citizen or permanent resident to sponsor their spouse or eligible relatives for immigration to the U.S. These two serve different purposes in the immigration process. Here's a quick quiz for you. What happens if a couple marries before the K-1 visa is approved? Is it A. They must apply for a tourist visa, B. They switch to the I-130 petition, or C. They can still use the K-1 visa? You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. Let's explore the reasons why you might want to switch from a K-1 visa to an I-130 petition. One common reason is if the couple marries before the K-1 visa is processed and approved. In such cases, they must switch to the I-130 route. Another reason could be significant delays in K-1 processing, making the I-130 petition a faster alternative. Lastly, unexpected circumstantial changes might make the K-1 visa less suitable for your needs and prompt a switch to I-130. If a couple marries before the K-1 visa is approved, they must switch to the I-130 petition to sponsor the foreign spouse for immigration. This flowchart illustrates the process of switching from a K-1 visa to an I-130 petition. It all begins with the withdrawal of the K-1 petition by submitting a formal request to USCIS. Once the K-1 petition is withdrawn, the next step is to file the I-130 petition, along with necessary supporting documents. Subsequently, your I-130 petition will undergo its own processing period. Finally, if the beneficiary is already in the U.S., they can apply to adjust their status to that of a lawful permanent resident while providing additional documentation. Now, let's look at some important considerations to keep in mind when switching from a K-1 visa to an I-130 petition. It's vital to note that both petitions have separate filing fees that need to be paid. Processing times for both petitions can vary based on the USCIS office and current caseload, so patience is key. Additionally, consulting with an immigration attorney is highly recommended, as they can provide valuable legal guidance throughout the process and help address any complexities involved. Important disclaimer. Remember, this video offers general information and should not be considered legal advice. Every immigration case is unique, so it's essential to always seek professional guidance from an immigration attorney for your specific situation. Thank you for joining us today. If you found this video helpful, please like, share, and subscribe to our channel for more content. We value your thoughts, so feel free to share them in the comments below. Until next time, take care.